Hi, my name is Annika Clinton, and today I'll be giving you a brief overview of my research paper, which is on the First Amendment, an analysis of free speech and access to social media. I chose this topic because I think the First Amendment is one of the most important parts of the Constitution that we have because it enables people to exercise their freedom of speech and expression. And it's interesting because with the addition of social media, the First Amendment has been more controversial with sites like Twitter and Instagram and Facebook coming up. There are new freedoms and responsibilities that it needs to address. Because social media offers new platforms for people to exercise their freedom of expression, there are new challenges that in determining the boundaries of protected speech. And the question is whether or not people have the right in their freedom of speech and what they access and post online. So a brief overview of some of the acts and cases that led to the current freedom of speech and social media that we have today is in 1986, the Electronic Communications Privacy Act was passed, which prohibits interception of any wire or electronic communication. So pretty much any kind of communication you have online, whether it's images, sounds, or data, is protected when it's in transit. And this came about by the case United States versus Councilman, where the question was raised whether emails were protected when they were in transit between people. Then the Speech Act of 2010 happened, which allowed federal law to make foreign libel judgments unenforceable in U.S. courts unless those judgments comply with the First Amendment. And then there was the Computer Fraud and Abuse Act, which what it pretty much does is protect people's rights of privacy on what they are posting on the internet. So in my recent case law, I chose to focus on the case of Packingham versus North Carolina, which happened in 2017. Pretty much this case arose after the arrest of Lester Gerard Packingham in 2010 after he had sexual relations with a minor back in 2002. And after Packingham had served his punishment in prison, he was denied access from using social media accounts because of his sex offender status. So pretty much after he was released from prison, he made a post on Facebook that was about a parking ticket. It wasn't threatening at all. It was very normal, mundane post, and he was charged under a North Carolina statute that prevents sex offenders from using social media sites due to their access to other people and danger to other people. And Packingham challenged this ruling, saying that the First Amendment rights were being denied by not allowing him to have access to or post freely online. So this case was ultimately taken to the Supreme Court, where they were asked to judge the First Amendment with scrutiny, and the end result was that the Supreme Court ruled North Carolina's statute unconstitutional because social media sites are protected space. And the social media sites in this protected space range all the way from Facebook to WebMD. And we wouldn't normally think of WebMD as a social media site, but it is protected under that protected space. So a case that was used in this decision was the Ashcroft versus the Speech Coalition, which happened in 2002, which was decided in this case that there were two overbroad provisions of the Child Pornography Prevention Act of 1996 because they encroached upon the freedom to engage in a substantial amount of unlawful speech, which was a big part in deciding that Packingham had a right to his social media usage despite his sex offender status. So my law review analysis was that people shouldn't necessarily lose their right to social media because of their criminal past. I think that if someone has served their time, that they shouldn't be restricted on social media, especially since the internet is such a prominent part of everyday life. People use it in their work to communicate with others, and I don't think that unless someone is breaking the law or being threatening or a danger to others, that they should have that taken away from them, because that's restricting their communication with the outside world. And also, being a sex offender status, that follows you your whole life. When you apply for a job, when you move houses, you have to say that you are a registered sex offender so as to protect the public. And I think that should, in the future, be a part of someone's social media usage, but shouldn't necessarily stop them from being able to use social media, just as it won't stop someone from getting a job or moving to a different house. And I think that in the future, for future research questions, it should be questioned whether or not other people who aren't necessarily sex offenders or criminals, if their restrictions from accessing social media is a restriction of freedom of speech as well. So I think that could be studied under more scrutiny to see how far the freedom of speech reaches when it comes to social media.